This is Barry Zellma speaking for Claim School Incorporated's blog, Zellma on Insurance. Today we're going to speak about why an agent's statement of coverage can bind the insurer and why it is not bad faith for an insurer to deny a claim if it does so with some reasonable basis. The California Court of Appeals dealt with a claim by Wynzell Lynn, Jr. in a breach of insurance contract case against defendants AAA Life Insurance Company and its agent, Craigory Webb. Plaintiff appealed from a final judgment of dismissal that was entered after the trial court struck certain causes of action in plaintiff's operative complaint and sustained the defendant's demurrer as to other causes of action without leave to amend. In Wynzell Lynn, Jr. v. AAA Life Insurance Company et al., the California Court of Appeal on February 9, 2024, explained in a lengthy opinion why the trial court erred. Plaintiff purchased from defendant AAA Life Insurance Company a life insurance policy for himself along with a child term rider, providing up to $10,000 in coverage per insured child. According to the First Amended Complaint, plaintiff understood from his pre-purchase conversations with the agent, Mr. Webb, that the rider would cover all of the children in plaintiff's household, even those without a biological or legally defined relationship, that is, as an adopted child, a foster child, or a stepchild to him. However, when one of the children in plaintiff's household, 17-year-old Maki Bowen, was murdered while the rider was in effect, AAA rejected plaintiff's claim for coverage because Bowen was not plaintiff's biological or legally recognized child. When plaintiff first contacted Webb, within their household were 4 children under the age of 19, 3 with plaintiff's surname, plus Bowen, who was the biological child of plaintiff's fiancé and another man. Bowen's biological father had died in 2007 when Bowen was only 4 years old, and Bowen had lived in plaintiff's household as part of plaintiff's family since he was about 6 years old. Although the fact alleged that Bowen was plaintiff's child since he was approximately 6 years old, all agreed that Bowen was not plaintiff's biological, step, adopted, or foster child. Webb, however, as the agent for the insurer, stated, the rider covers all your children for $7. The 3-page rider contained the following relevant provisions. That is, the rider, quote, provides term life insurance coverage for each insured child. An eligible child must be dependent upon the insured for support in living within the insured's household or attending an educational institution as a full-time or part-time student. In November of 2020, after 7 months after plaintiff's policy became effective, tragically, Bowen was fatally shot. On the date of his death, Bowen was 17 years old, unmarried, financially dependent on the plaintiff, and living in plaintiff's household. Plaintiff contacted Webb to inform him of the death, and Webb again represented to plaintiff that the child term rider would provide coverage, and told plaintiff how he could initiate his claim. AAA formally denied plaintiff's claim under the rider, stating in its final rejection letter that Bowen was not a qualifying child. The Court of Appeal first dealt with the breach of contract claim, that of an express contract. The trial court sustained the demurrer for failure to plead a breach of the rider by AAA. The definition of eligible child, as it appears in the rider's first paragraph, is on its face ambiguous in that it is susceptible to more than one reasonable interpretation as to whom the term coverage. The Court of Appeals noted that definition of the term as denoted in the first paragraph can reasonably be read as the trial court read it, to limit coverage of the policy's effective date to children who meet all the undisputed criteria and are insured's biological adopted step or foster children, that is, children who are encompassed in the categories specified in the second paragraph of the definition. The definition can also, according to the Court of Appeal, reasonably be read to provide coverage as of the policy's effective date for children who meet all the undisputed criteria and are openly held out by the insured to be his children, consistent with California parentage law. As discussed in the opinion, California parentage law creates a presumption that a person who openly holds himself out as the child of his own is the child's natural parent. To the extent the writer can reasonably be interpreted to provide coverage for a child with a relationship to the insured akin to Bowen's relationship with plaintiff, the fact properly pleads the element of breach, the only element the trial court found missing. Defendant's contention that the phrase all of the insured's children, an interpretation of the writer to the effect it covers children who were adopted by the insured or became his stepchildren or court-appointed foster children after it took effect, but not the insured's existing adopted children, stepchildren, and court-appointed foster children as of the effective date, would be unreasonable. The Court of Appeals concluded the eligible child in the first paragraph of the writer is ambiguous in that it is reasonably susceptible to two interpretations. The fact liberally construed indicates that plaintiff held Bowen out as his child. The fact also alleges that Bowen lived in plaintiff's household and was dependent on plaintiff for support. Accordingly, in light of its ambiguity, the definition of eligible child in the first paragraph must be construed to protect the expectation. In addition, in a case called Shade Foods, Inc. versus Innovative Products Sales and Marketing, the Court of Appeals held that an insurance carrier is bound by its agent's interpretation of coverage under the policy, and an agent's authority to bind the principal unquestionably extends to giving ambiguous contract provisions an interpretation that the insurer itself might reasonably adopt. As a result, the court concluded the insurer was bound by its agent's interpretation of the contract. The mere fact that an insurer, however, withholds coverage based on an erroneous interpretation of the policy does not necessarily mean that there was a breach of the covenant of good faith and fair dealing. To be liable in tort, the insurer must have acted unreasonably. Although the reasonableness of an insurer's denial of benefits is ordinarily a question of fact, a court can conclude as a matter of law that the insured's denial of a claim is not unreasonable as long as there existed a genuine issue as to the insurer's liability. The trial court's dismissal of the fact's cause of action for breach of contract on an express contract theory, defendants argue in the alternative that plaintiff cannot plead his tort claim, that is, breach of the covenant, because AAA's interpretation of the writer was reasonable and therefore shielded by the genuine dispute doctrine. The Court of Appeals agreed with AAA, and it affirmed the trial court's dismissal of plaintiff's breach of covenant claim. An insurance agent, however, has an obligation to use reasonable care, diligence, and judgment in procuring insurance requested by an insured. The law is well established in California that an agent's failure to deliver the agreed-upon coverage may constitute actionable negligence and the proximate cause of an injury, and accordingly it concluded that the fact alleges adequate facts to show a special duty of care, breach of that duty, causation, and damages. The judgment of dismissal was therefore reversed. The matter was remanded with instructions to the trial court to vacate the order sustaining the demurrer without leave to amend and to enter a new order, 1, overruling the demurrer to the breach of contract cause of action, 2, sustaining the demurrer to the breach of the covenant of good faith and fair dealing cause of action, with leave for plaintiff to further amend his complaint to allege, if he is able, causes of action against AAA for breach of the contract by estoppel, against AAA and Webb for violation of the Business and Professions Code, Section 17,200 et sec, against AAA and Webb for negligent misrepresentation, against AAA and Webb for negligence and for reformation based on mutual mistake. The parties, of course, were ordered to share their own costs on appeal. In my opinion, this case over a $10,000 dispute went through a claim denial, a demurrer dismissing the entire action, an appeal, a reversal of the breach of contract claim, and a return to the trial court to allow amendment of a statutory breach claim if possible, and trial on the breach of contract case. No bad faith, because it took the court to find a statute making a person, quote, held out as a son, close quote, to be a son, even if there's no physical natural relationship nor a relationship by adoption or court order. This is a case where the concept of millions for defense and not a dime for tribute requires reconsideration, mediation, and settlement, especially now that there is no opportunity for bad faith damages. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Please tell your friends and colleagues about the blog and the videos, and let them subscribe to the blog and videos. They're all free. And you can also subscribe to the videos for free at YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.